Right. All right, let's get started. Hello, and welcome to Legal Aid's GRadulting Workshop Series. My name is Debbie McCutsky, and I'm the coordinator of services and programs for graduate student legal aid. Our focus today is security deposits and how to get that money back. Before we start the presentation, I want to tell you a little bit about legal aid. First of all, there are two legal aid offices on campus. One is for undergraduate students and the other is for grad students. So what does legal aid do? Well, in addition to workshops like this, we provide support to students in four main areas. Number one, legal consultations for local issues. Two, legal consultations for immigration issues. Three, advocacy for students who are facing university charges and for Title IX issues. And four, notary services. So the good news is if you've paid your student fee, you've already paid for our services. So there's no additional charge and no reason to not ask us for help. So I encourage you to visit our website to learn more about our services and to find out how to request an appointment. So we just have a few rules of engagement. This session is being recorded. The recording will be shared tomorrow along with the slides and any other resources that may come up. If you have questions, we encourage that. We want to hear from you. Please use the Q&A feature, not the chat, the Q&A. The speakers will answer questions, some of the questions during the presentation and others potentially afterwards. So don't be shy about asking for questions. Let's move on to the workshop. So I'm so pleased to introduce our speakers. They are both our attorneys from Legal Aid. First up is Syndy Shilling. She is the director and attorney for undergraduate student legal aid. Thank you, Syndy. And we also have William Mundy, otherwise known as Zach. And Zach is the director and attorney for graduate legal aid. Welcome, Zach. So thank you both. So I just get us started. Tell us how to get our money back.
Okay. And I'm going to give everybody a disclaimer that I am fighting a very scratchy throat with some coughing. So Zach may take over at some point. So if he does more talking than me, thank you, Zach, for doing that. But why don't you kick off, Zach?
Sure. And so the first question is, what is a security deposit? As a tenant, if you're seeking help with your security deposit, you might know this already, but the security deposit is the amount of money that you pay to a landlord to protect their investment. So it's not always great. It's not really in your best interest. It's you're giving them an amount of money to help cover any future damage or failure to pay rent that that may occur during the lease term. The most that a landlord can charge in Maryland is 2 months rent. I guess we should also do a quick preface of, we know that a lot of our students live maybe in DC or Northern Virginia, but the information that we're going to give today is going to be geared towards Maryland, but feel free to follow up with us for more specific questions about DC or Maryland, because sometimes there's some small differences. And one other thing about a security deposit in Maryland is that the landlord is required to give you a receipt that they provided you, that you have submitted the security deposit. Sometimes that is just a portion of the lease that says signing of this lease counts as receipt, and other times it could be an email or an actual paper receipt, but that is required to be provided.
I can take this one. So in Maryland, the landlord has 45 days after the rental period, so after the lease ends, to return either the security deposit in its entirety or a portion of your security deposit, along with an itemized list of what they're withholding for damages, or none of the deposit and explaining why all of that deposit money is needed to address damages in an itemized fashion. Or in worst case scenarios, they keep your security deposit, and they charge you more because the damages exceed the amount of the security deposit. So any of those scenarios can happen, but within that 45-day period, they have to let you know what is happening and return any of that money along with an itemized list. And they have to do that at your last known address that you provided to the landlord, and they do it by first-class mail. So you want to be watching out. Now, you may have other arrangements. You may arrange that you paid your rent via Zelle or some other electronic form, and you have an agreement that it's going to be returned. But if not, it defaults to first-class mail.
Next up, we have, can a landlord keep my deposit for any type of damage? And the answer is no. The only type of damage that they can withhold for is damage that exceeds ordinary wear and tear or normal wear and tear. And it must be an amount equal to the actual damages suffered. So that's the amount that it actually costs them to repair the damage that you caused. They can't just make up a number and charge you what they think it would cost. It has to be an amount equal to the actual damages suffered. And so here we have an example that says, when Jane moved out, the landlord tried to keep her deposit to repaint the apartment and replace the living room carpet. But Jane didn't damage the carpet past ordinary or the walls past ordinary wear and tear. So the landlord was not entitled to keep any money from the security deposit. And so it has to be beyond ordinary wear and tear, which means normal use of the property while you're living there. And it has to be for the actual amount that it costs to repair it, and not beyond that.
And I'll also add a little anecdotal story here. I've had students who actually get in touch with new tenants because landlords have said, I'm going to repaint, I'm going to recarpet, I'm keeping your money for this. And they come to find out through the new tenants that the landlord doesn't actually do any of that, just keeps the money and doesn't use it for those charges. So you also have a case to get that money back too if that occurs. I think Zach just explained this, but the difference between wear and tear is that wear and tear is what comes from just regular use of whatever that item is intended for. So if there's carpet that's worn and that's because you've walked on it all year, that's wear and tear. But if you knock a hole in the wall or you burn a cigarette in the carpet, that's damage that you're going to have to pay for.
Can I be present at the inspection? Yes, you do have a right to be there, but the law has some stringent requirements. Let's say for the landlord has to tell you when the inspection is taking place. If you have provided that notice that you want to be there, it must happen at least 15 days prior to moving, and the law says you must send it by certified mail, which is the non-intuitive aspect of it. A lot of times you might just ask the day you're moving out for the landlord to come. And the law for some reason says you have to do it. So if you want to be there, which is important, it's a good way to protect your security deposit and have a face-to-face conversation with the landlord about some of the damage in the unit, whether it was there before you got there, or whether you caused it, or whether it was just due to ordinary wear and tear. Then it's good to send that notice at least 15 days prior to the mailing address that the landlord has listed in the lease. The inspection itself must be held within a sort of a 10-day window. It's 5 days before, up to 5 days after the move out, and that's when it should be scheduled if you provide that proper notice, or that's when it should occur, even if you don't provide that proper notice anyway. And the landlord must tell you that you have a right to do this in your lease. It's one of the requirements that leases provide that in Prince George's County and in Maryland.
And again, this is not in the presentation, but I always suggest that not only do you request to be present at the move out inspection, but that you request a move in inspection with the landlord present. They're not required to do that, but if they're willing to do that, it's a good way to compare before and after. You go through the property, you can take photos. If you see damage when you're moving in, like a hole in the wall that was caused by the prior tenant, you want to make sure that the landlord acknowledges that that is not damage that you've caused because you're just moving in. And if they're not willing to be there, or they live out of state and they can't be there, you could either FaceTime Or still do the move-in inspection yourself with a checklist. You can just Google move-in inspection checklist on the internet, print out a form, do that yourself, and your lease is going to require you to immediately notify the landlord of any damage. And you want to do that right away so that you can establish that you're not the one responsible for it. One thing you want to note, so do I have to give my landlord notice before moving? The simple answer is yes. You want to look at your lease to see how many days is required for you to tell them in advance. And this is also not intuitive because you think, well, my lease ends on July 31st. So landlord knows I'm going to move out on July 31st. Not necessarily. So if your lease requires notice, make sure that you give it in writing. Make sure that you send it by certified mail. And you simply say, as you know, this lease terminates on July 31st. I intend to move out on that date. Okay.
Yeah, and just a tip on that one, I always tell students more in the fall than when we're dealing with security deposits. The day you sign your lease is the day you need to set up your Google Calendar reminder for when your notice is due, and maybe set it 15 or 30 days ahead of when that notice is due so that you have time to think about and actually make the decision. But landlords in this area in Prince George's County and DC are not going to give you much wiggle room with that notice and going to try to charge you for an extra month's rent, which is very frustrating. So
Yeah.
next, go ahead. Sorry, Cindy.
I was just going to say, I probably left out the point of this is that if you don't give the required notice, your lease is going to automatically renew and it's going to default to month. So that's why they're justified in charging you for another month's rent.
When should you get your deposit back? And so the law in Maryland is,
I think that's a duplicate, right? Did I already go over that?
I don't think so. I think we just talked about notice, but I think we mentioned it earlier, but yeah, the short answer is they have 45 days to send it back to you, or to, if they're withholding all of it, then they must provide you that list of withholdings within that 45-day period. Or if it's a partial, then they must return partial and provide you the list of what the withholdings were for. As Cindy said, the default is by first class mail that they'll send it to your forwarding address, especially for the notice if there are withholdings. But in some cases, they might return the deposit based on what the lease says. So they're supposed to mail you a check if it doesn't say it in your lease. But if your lease says they're going to PayPal, Zelle it, Cash App it back to you, then that's okay as well. But it needs to occur within the 45 days, or else you can be entitled to the full return of your deposit.
So what happens if I break the lease? So the minute you sign the lease, that's when you've created a binding contract. That's when you have agreed to lease it for that term at the rent that's specified. But having said that, circumstances do come up where lots of students try to break a lease. I just had a case this morning where there is roommate friction. They want to get out of the lease. The landlord doesn't care about roommate friction, right? The landlord wants you to honor the lease, pay the rent, and he or she gets their money. Having said that, if you do break the lease, the landlord is almost surely going to come after you because there's an acceleration clause that basically says, if I move out and I breach the lease, then the landlord can immediately come after me for all the monies that are due for the remainder of the lease. So if it's a 12-month lease and you move out after month 6, then the landlord can come after you for that remaining 6-month period. If that happens, the landlord has to put the unit back on the market and try to mitigate damages. So they want landlords to have an incentive to get people in there. And if that happens, you're not responsible for the portion of the rent that new tenant pays. But let's say there's a 2-month gap between when the landlord can fill that unit again, you're still going to be responsible for that gap period. Also, if the landlord can only lease it for less money, less rent, you may be responsible for that gap in what you paid and what the new tenant is paying. So the tip here is a long-term lease is a big obligation, lots of money. So anticipate life changes, see if maybe you can negotiate a month-to-month lease or a shorter term, because once you sign that lease, you're bound.
What is an eviction? So an eviction is the legal process for the landlord kicking you out. They can't just automatically change the locks or remove your belongings. There's a formal process that they must go through. So they must file an action in court. And in most circumstances, pretty much every circumstance, they must provide you a notice even before they're able to file in court, whether that's a notice for non-payment of rent, whether that's a notice for you breaching the lease, like maybe you have a pet and you're not supposed to, maybe you moved in some roommates without telling them. They have to give you a notice to correct and to allow you to fix whatever the issue is in the first place. But if you don't correct or if you don't move out after that time period is up, the landlord can evict you and they can request the court to kick you out. You do have protections that they can't do it just because you filed a complaint against them or that you have joined a tenant association to try to advocate on behalf of tenants as a group. But for non-payment of rent, holding over, meaning not moving out after you after the lease expires or after you provided a notice to vacate, breach of the lease or illegal drug activity, they can evict you. If you ever get any kind of notice for eviction and you're still a student here, come to our office immediately because it is a serious issue that you want to make sure that you're approaching the right way. And even if you're not a student here anymore, there will be other resources. You should contact Maryland Legal Aid, or you should contact the help desk at your local district court or circuit court, depending on what's going on, to figure out, make sure that all your rights are protected.
Okay, you want to keep going on this since this is still
Sure,
eviction?
yeah. And so this is just a little bit more about what happens if I get evicted. You'll receive an official summons, and a summons is a notice from the court that says you have to appear. This gives you a chance to defend yourself. So whenever someone files a court case against you, they have to provide you that proper notice so that you know when it's going to take place. The court will tell you when and where to show up, and you can go explain what happened. You can say, actually, I did pay my rent, but my landlord lost I handed him the check, he lost it. So and I didn't give him another one because I didn't trust him with it, whatever the situation may be. Or if he's saying your landlord is trying to throw you out for having too many parties and being too noisy, you can say that you weren't, and that it was maybe a neighbor who you were wrongly accused of. And so then the judge will determine whether or not there are grounds for you to be evicted. If they do find that you can be evicted, then the landlord can officially seek that permission from the court to evict you, to change the locks, to remove your belongings so that you no longer have access to or possession of the property.
And I think a lot of first-time renters may not know this, but they can't just tell you to get out, right? They can't come change the locks. They have to go through this court proceeding to get the sheriff to come and evict you. So if landlords start threatening to throw you out or to come change the locks, just know they can't do that. And it is, in Prince George's County, landlord-tenant court is busy. So it's not a quick process all the time. So you're going to have time to prepare for that hearing. There's an appeal process that you may be able to use. So never let a landlord just throw you out on the spot. Okay, so what happens to my security deposit if I break my lease or get evicted? So as we said, within 45 days after leaving the premises, you have to send to the landlord a request for the return of the security deposit and let the landlord know of your new address. And then within 45 days of that notice, the landlord has to send the list of damages deducted from the security deposit, as well as, we said, a very itemized statement of costs that were actually incurred, not just hypothetical, minus the damages from the security deposit. Now, what will I do if the landlord still won't return my security deposit and they ghost you, you don't hear from them, it's been 90 days? Really, on the 46th day, you can take action. So obviously, we recommend that you make an appointment with us so that we can help you with the process. And then you go to the district court. We have one very convenient to campus right in Hyattsville. And you file a complaint against them. And not only for the security deposit itself, but once they violated the statute that says they have 45 days, you can ask for 3 times what you're owed. So if you put down a security deposit of $1,000, you can actually ask the court to award you 3 times that, or $3,000. I'll let Zach talk through that process a little bit more.
Yep, and right before I talk about small claims, I am going to drop a link in the chat. We had a question that is all of this info and guidance specific to Prince George's County, because I live in Baltimore City, so would it be different? The short answer is 99% of this is going to be exactly the same, because it's governed by Maryland state law. In Baltimore City, there are a couple extra protections that you're going to have with longer notice periods when it comes to eviction and when you can get evicted after the court says you can. And so I just put a link in the chat that addresses some of those extra protections. But for security deposit issues and how small claims works, all of that's going to be exactly the same. And so how do I file a complaint in small claims court? Well, you can obviously make an appointment with us and talk it through. But the closest small claims court, the small claims courts, is sort of an informal terminology that is for claims less than $5,000 in Maryland. If you're in DC, it goes up to $10,000. But small claims courts are in the district courts within the counties. And so the local one here in Prince George's County is in Hyattsville. It's a few miles south of campus on Baltimore Avenue. You fill out the district court complaint form, which is a very straightforward one-page form that sort of asks you for your contact information, the contact information from your landlord for a security deposit issue, which should be listed on the lease. It gives you about 10 to 12 lines to explain why you're filing this action. And so you don't need to write a novel. It's just about explaining in a simple way, clear and concise way, why you were filed this complaint. And then you can attach pictures or cancel checks or any correspondence that you've had. And you take it to the courthouse in the county which you live in, which, as I mentioned, would be Hyattsville here is the closest one. You pay the filing fee, which is about $40, and then you have to serve the landlord, which just means provide formal notice that you have filed the complaint against them. And there are a few different ways to do that. The easiest way is by certified mail, which will just cost you an additional $7 or so. It used to be $6.75, but I don't know if they've raised it since I last checked. Or you can pay the sheriff's office to do it, or anyone over the age of 18 who is not involved in the case can do it as well. And then they have to sign an affidavit and submit it to the court for proof that they have served the landlord. But for most landlords, certified mail is the way to go, and they will accept it and sign for it.
And make sure you keep your receipt for the filing fee and for the certified mail fee, because there's a place on the form where you can ask for the court to award you court costs as part of what the landlord has to pay you. There's the form. Very simple, one pager. We can help you navigate that form and help you say what you need to say over there in the narrative section. You will need to know where the landlord physically resides. You need to be able to find them to serve them. So make sure as part of the leasing process that you have that contact information for your landlord. Here's how you contact us, because that's a good first step. We'll navigate through the whole process with you. We don't go to court with you. We don't represent you in front of the court, and we can't file the forms for you, but we can walk you through in detail exactly what you have to do. And there are both of our email addresses. And I think that is it. Any more questions for us?
I also just dropped the Maryland courts have a 25-ish page PDF that is a handbook, a guide to small claims court that really, even when you look at that form, it'll go through line by line and tell you what information you put here, what information you put there. And the one thing that it's especially helpful for is most people, when we mention service, the formal way you have to notify the person you're suing, it's sometimes complicated. And so this does a good job of explaining those different options and telling you why one might be better than the other for some of your specific circumstances. So it's a good resource to browse through. And then any questions that you still have after that, reach out to us.
And just know, and that document that Zach dropped will tell you this, you can't serve the landlord. One party can't serve the other. So you either have to use that certified mail process, find a friend who's over 18 who will do it for you. There's an extra step that has to happen for that, or any of the other options, but that document will walk you through those. Any questions from anyone?
I had a question. When you guys say 45 days after, you got 45 days to get the security deposit back, does that mean 45 days after the lease is over?
Yes.
Okay.
So if your lease ends on July 31st, they're going to have until September 15th.
Yeah, and one thing I will say, sort of touching on one of Cindy's points earlier, for when you are, if you do move out early and or terminating early and you're trying to work out a negotiation with your landlord, the security deposit is always one of those things that you want to include in that final agreement. Like, not just we're moving out and terminating on this date. Make sure that you're trying to protect your security deposit and either guaranteeing the full return of it, but you can also expedite it if the landlord is willing. You can say, and the landlord will return the deposit within 15 days, because I know that when I was a student, both in undergrad and grad school, I was broke, and waiting that 45 days when I already had to put a deposit on the new place was always a stretch for me. And so, you can, if you are moving out early, some sort of negotiation, or even just have a good relationship with your landlord, you can request that. They're not obligated to do it, but in some cases they might if you've been a good tenant.
And I will also say there are a lot of good landlords here, but there are a few bad apples. So it's always just like staying in touch with incoming tenants. It's not a bad thing if you can get in touch with current tenants to say, or prior tenants to say, how has this landlord been in general? If you know people, because these bad apples rent the same houses every year. If you know people have lived there before, does this landlord have a reputation for withholding security deposits? Because there are some that just make a practice of it and they don't return any of the deposit and then they charge over that. We had a case last semester where the deposit was, I think it was $8,000, and then the landlord came after that group of tenants for an additional $6,000. So it was $14,000. It ended up going to court and the tenants did okay. They lost a lot less than that, but it was quite a fiasco.
My house had a very similar issue, so this might be the same landlord, but the past tenants, we didn't know this before we moved in, but they didn't get their security deposit back, and I think it's like $8,000. So that's something I'm concerned about.
Yeah, always watch out. Again, there's not a lot of them, but we hear the same names over and over. Good point. Any other questions?
Cindy, there was one put in the Q&A that asked, are we able to get support from your office even after we've graduated? I can tell you that for GLAO, so our office is funded by student fees, so we get part of the graduate student activity fee, and that's paid only in the fall and spring semesters. And so the way that our office views it is that we will continue to support you up until the next semester has started. And so if you graduate in May, but obviously your deposit, you might not have an issue until July or even August, you can still come to us in July and August, and we will help you and help point you in the right direction. And Cindy, what does your office do?
Exact same thing. So this summer, if something happens and you're graduating in May, you can still come to us for help. And the best way to book with undergrad, that legalaid.umd.edu link will take you to both of our offices, and you can choose undergrad or graduate. And then we both have different ways of booking appointments. So just go to that website and click on what kind of student you are.
Yep, well, both of them are through online portals, so you don't have to call us or anything like that. For ours, you just submit a little questionnaire, and then after we get your questionnaire, we'll email you a link and you can pick an appointment time that works for you that is available.
And we do virtual and in-person appointments here. I'm not as frequently in the office over the summer, so if you're an undergrad student and you need help over the summer and you don't see appointments available, best way to get in touch is just to email slough@umd.edu and we'll get you set up based on just working around my schedule.
Any other questions?
Everybody good? Debbie, you want to wrap things up?
Yeah, these folks are ready to get their money back. Thanks to you. Thank you so much, Syndy and Zach. That was terrific.
Great to be here. Thanks for
Thanks, Debbie.
everybody coming.
Yeah, thanks everyone. It's good for us to spend some time together, and I hope this was helpful to you. Tomorrow, I will send out an email to all the registrants with information that was presented at this workshop. So now all you have to do is have a good week, and good luck making it through the end of the semester. And as always, let us know how legal aid can help you.
Bye,
Bye.
everybody.
Bye, everybody.